I'd like to say hello and welcome everyone in our Zoom audience. I'm Terry Maggedy, chair of the Elder Law Committee of the Trust and Estates section of the Beverly Hills Bar Association. And the first thing we do before we start our program is of course, express our appreciation to our sponsor. Our sponsor is the Sanborn team. They've been a sponsor for many, many years now, and really their sponsorship allows us to do what we need to do, carry on programs the way we have in the past and continue to do. The Sanborn team, and specifically Nancy Sanborn, the principal, are real estate experts in the areas of law that we deal with in the elder law, probate, trust arena. They're experts in real estate for probates, experts in real estate for trust administration, expert in real estate and conservatorships, just real estate even that connects in anywhere with anyway with older people. They're excellent. They're a great outfit, and I want to thank them for being our sponsors. And now we will start our program. So our speaker today, Randy Spiro, is a regular participant for our committee. Usually once a year, Randy presents to us on a very interesting topic. Randy's such a thoughtful person, attorney, top-notch estate planner, and it's always interesting to hear his thoughts on a subject. And usually every year he does something that's timely. And of course, what could be more timely right now than COVID-19? So our program today is estate planning for older adults through the lens of COVID-19 virus. That's our program. And with that, I'll turn it over to Randy.
Thank you, Terry. We're going to do questions and answers at the end. I just want to make sure we don't go over, and I'm sure we won't. So there'll be time. This topic 100 years ago we had something similar, but I'm not sure estate planning was anywhere near as developed back then as it is today. So maybe lawyers 100 years ago weren't thinking quite as much about what to do. But this COVID and estate planning, we're going to be talking about ethical issues that it brings up, malpractice issues, and scope of duty issues, which kind of go together. Most of it is really practical issues. How do we do things differently, and how do we do things consistently with what we did in the past? Legal fee issues, is it going to take us a lot more time to deal with these problems? Abandonment issues, where we say, I don't know if I want to continue with something, but if you try to get out, who's going to help the client? Once you're in, it's even harder getting out in a COVID situation than a more normal one. Specialization issues, where because of COVID, there's litigation issues, there's conservatorship issues, there's ex-party issues. There's all kinds of issues that you might not have otherwise been involved in. And is this something that you can do, or do you need to farm it out? So the first question that I think all of us have to ask ourselves, Roman numeral 1 on my outline, is will you start an estate plan for someone who has tested positive for COVID-19? The only good thing about it is if you know about it up front, you can decide if you want it. You can figure out the fee issue. Is it going to be a flat fee? Is it going to be an hourly? Is it going to be a combination of the two? You'll try to figure out these issues of notarizations and witnessing and face-to-face and not face-to-face and other issues, and you can do that up front. So in a way, it seems worse to have somebody to know your client has COVID, but in a way it's better because you can plan for it and it doesn't hit you midway through the process. And I think we've all had clients where we've started an estate plan and it doesn't take them a week or a month to sign, but it was 2 months and 6 months. And I'm sure a lot of you have records where it took a year or two or more between when you started the estate plan and the client finally signed everything. So the question is, what happens when you start the estate plan? There's no COVID, so you're not thinking about distancing issues, and all of a sudden hits you before anything is signed. Or another situation where you've completed the estate plan, but now the client wants to amend the trust, and what are you going to do where the client can't meet you face to face, and you've already done the trust, so you have a lot of feelings about helping this client, and they've got COVID, and just before they decided they wanted an amendment. So let's go to some of the meat of some of this, and I think one theme that's going to run through a lot of this is that whatever you do to deal with the issues that we're going to talk about, I'm going to suggest you document your efforts by emails and by other methods, because sometimes you're going to fall short in terms of getting the job done, and sometimes the client is going to die before it gets done, or become so incapacitated that nothing can be signed. And so one of the ideas is to try to put the ball into the client's court, and if there's any other people that are helping the client, those as well, because ultimately the question will come up, why didn't this get done? And so documentation is really important. The first thing that came out very recently was that the California Secretary of State has now blessed the remote notarization of documents, which could be a trust, an amendment, a deed, anything, except that this remote notarization cannot occur in the state of California because notaries in California are not allowed to do that. So how did he bless something we're not allowed to do? And I think a lot of you have already heard this, and that is that there are some states that allow remote notarization. And therefore, if you're sitting in California and you're online with a notary, let's say in Nevada, it's as if you're in Nevada. And therefore, if it's legal in Nevada and you're here and the notary's in Nevada, you can do it, except before the Secretary of State acknowledged that, no one really knew that was true. So I don't think there was that much remote notarization in California, remote notarizing through a notary in Nevada, prior to the Secretary of State announcing this, because what if he didn't accept it? But he took a reasonable approach. That's Alex Padilla, and said that under Civil Code Section 1189B, the Notary Act basically is occurring in Nevada, because that's where the notary is. And so we looked to Nevada law, and California recognizes that Nevada law. So you've got remote notarization, and you can go to notarycam.com. You can go to notarize.com. I've given out those numbers. I've told people I haven't had great experiences or bad experiences. I've had little experience with these companies, and there's other companies, but just simply so if you put in an email to the client that one of their options is to use one of these services, that's one of these documentation issues, in the sense that if nothing ever gets done, and the client or the child or somebody says, that lawyer basically said that we should wait until all this is over with because we need it to be notarized, and we can't notarize in his office until then. Well, you're not saying that. And but putting out that there's this remote notarization is really a good way of proving that you were not saying that the only way to get this done was to have a face-to-face, or to go to some other notary face-to-face, or go to you face-to-face. Now, obviously, it's optimum, and it's best for the client to come back to the lawyer, and there's a lot of discussion about the duty of the client to supervise the process, and certainly that's optimum. But if a lawyer says, well, if I can't supervise the process, we'll just wait, I just think that there's a lot of liability issues that rear their head if the client dies. So the client may choose to wait, but hopefully it's not because you've suggested that they wait, because if they die, it's just one more exposure for all of us. So it turns out that if you have a trust or an amendment to a trust, there's no law that requires it be notarized. Now, you might have a trust that says in order to amend it, the amendment has to be notarized. That's a different story, but there's no inherent law that says that the trust or the amendment has to be notarized. So one idea here would be that if there's a problem, one of the options is for the client to sign the trust, sign the amendment without a notary, and then maybe later, as soon as it's feasible, through one of these other methods, go back and get it signed and notarized. But again, if he signs it and it's not notarized, it can still be a legal document, and that's one of the options. And it's not a good option, but if that's the only thing the client's willing to do is to sign it with no notary, doesn't know how to go online to do remote, etc. So it is something to think about and to put out there, because there may be a question. Well, nobody told my dad that this document could have been signed without a notary, and dad thought it had to have been, and that's your fault. Well, and I'm not saying it is, but these are things that we want to think about a little bit, and I've got a lot more of those because I've spent a little time thinking about this, and believe me, the answers that I've come up with, or the ideas that I've come up with, were things that I didn't even think about prior to this COVID-19. So you'll come up with hopefully some of your own. So we have the Roman numeral 4, that there is no remote witnessing of wills in California. Other states, maybe. But that's a problem, because it's not like you can get a notary in Nevada to help you with the witnessing of the wills. The remote witnessing, we believe, doesn't exist. Maybe there'll be a case where it's done remotely and the court will approve it. But I'm certainly not here to say that is an approved technique. And I'm not saying it isn't, but it would be a scary technique. And I think I've got a few others that are, to me, less scary. So if you've got this trust and you've signed it and you'll notarize it later, or you're notarizing it online, you need this pour over will, because you don't know to what extent the trust is going to be funded. But the pour over will is a formal will, and you've got the witnessing requirements. But now you've got a holographic will. Well, most of us haven't dealt much, and I never really have, with a handwritten pour over will, a holographic pour over will. But the truth is, there's no reason you can't do one. People think our clients think of a pour over will as something that's not exactly a will. It's like stands on its own. No, a pour over will is a type of a will, and if you can do a holographic will, you can do a holographic pour over will. So that can work fine. But you have a lot of situations with these clients that have COVID, or they're very elderly and have other issues. How much can they really write beyond their signature? They may be okay mentally, but physically it can be strenuous the more they write. So if you have a 5-page pour over will, or even a 3-page pour over will, that client may be okay for signing all the documents, but just can't write that many pages, doesn't have the strength, doesn't, after the first sentences, everything becomes illegible. So the question is, you could create a pour over, a holographic handwritten pour over will that's fairly short. Instead of our normal stuff where you have the powers of the trustee and this and that, you basically recite that this is my will, and that you recite who your spouse and children are, and you recite that you give all your assets to the so-and-so trust, and then you can, another sentence, to appoint an executor and so is backup. If they have enough strength left, they'll put something in about waiving bond, and if not, they'll have a bond. And then you've got it dated and signed. So the idea of a holographic pour over will for this person that's remotely signing and can't get the witnesses in there because everybody's frightened. They may be staying at a facility, and the facility may be putting the food outside their door. And it used to be that the people at the facility might come in and they might be witnesses, but now good luck that the folks at the facility don't want to catch the COVID themselves, and if they have it, they don't want to be accused of giving it to the person, to the client or patient, whatever you want to call them. So you just open the door and get the stuff, put it out, and there's no interaction. So you may not really, even at a facility, you may not be able to get your witnesses. And it's so sad where people have elderly parents and elderly other relatives, and you can't see them. And everybody knows that if they have COVID, that or that you might have it and give it to them, that's a problem. So this holographic is one way to do it. Going to Roman numeral 6, basically there's another way to deal with this, and it's one that I really didn't know much about. And Probate Code 6110C1 has the traditional 2 witnesses rule. They're together in the same room, and you don't want the witnesses to be beneficiaries, and which, if they are, they could be limited to their intestate share, and all of that. But then you've got the subsection C2, 6110C2, that says that if you comply with this C2 procedure, then you don't need to have the 2 witnesses. But that procedure involves establishing by clear and convincing evidence that at the time the testator signed the will, very important, at the time the testator signed the will, he or she intended it to constitute his or her will. So I think it's been very rare that lawyers have used that technique. In fact, in most cases, when a will doesn't have the witnesses, a lot of us are kind of throwing up our hands, and maybe some of us that are litigators have used this technique to try to take a will and breathe life back into it, because it isn't all handwritten, it's not holographic, and there's either 0 witnesses or 1 witness, or the witnesses weren't in the same room at the same time, or there was some other technical problem. So this clear and convincing evidence standard is higher than the preponderance of the evidence standard when it's greater than 50%, and it's lower than the criminal standard, which is up above 80%. How much more? You can ask the criminal lawyers how high that is. But it's an in-between standard, and some people have called it the firm belief standard, that we have the firm belief that this person really intended this as his will. So if we're gonna do that type of a thing, what do we do? How do we approach that? Well, first we examine other options, and in fact, if we're going to do this, we want to have some documentation that we've tried other things and we've been relegated down to this technique, rather than we started this technique and didn't try some of the other options, or that you're not sure that the other options worked, and therefore you're trying to do this as a backup just in case. What if you weren't there and the 2 witnesses weren't in the same room at the same time and you didn't know it? Or what if one of the witnesses was 17 years old? Or what if a lot of things? This whole C2 statute comes from something called the harmless error approach of Professor John Langbine, which his approach was adopted by the Uniform Probate Code in 1990. And then in modified form, it was adopted by California in 2008. There was a lawyer, Sil Regiardo, who kind of championed this approach or brought it to everybody's attention, but I don't think it's been brought to everybody's attention. A lot of people don't know much about it. So let's say you email the typed pour-over will to the client, and he develops COVID. He can't have witnesses come in. Maybe he can. It's still worth asking. Maybe there's caregivers with the client, and they'll be willing to act as witnesses. So you've got different ways that you can back up this thing to try to meet this high standard. You could have a Skype session with the client before and after. You could have a Zoom session with the client before or after. You could have a Facebook session before or after. And whatever session you have before or after, you're documenting in your memo to file, and then you're emailing the client saying just per the this and that, this and this happened, and we agreed to this, and you told me that. You're memorializing everything you do, and now you want that same client to tell people that would have been his witnesses. They can't be witnesses, they're not coming in, but the people that would have been witnesses, and maybe not just 2 of them, 3, 4, 5, 10, the more the merrier. Tell these people before he or she signs, and that he or she intends to sign this will, that he's read the will, he understands the will represents his wishes. If it's a pour-over will, the client should say to the friends, the witnesses, that hey, I've got a trust, and I understand my trust, and I understand that this will doesn't contain the disposition of my assets, and my trust does, and I've signed my trust, and that trust is good. So when I say I want my will to give everything to my trust, I understand that the will is going to, in essence, flow into the disposition that's in the trust. So the more the client can show that he understands what's going on, or she, the better. So you've got these witnesses that aren't witnesses, but the client is talking to them, emailing them, Skyping them before and after, and then have these witnesses, as well as yourself, sign some affidavits about this, and focus on the intent at the time of the signing rather than the time of the acknowledgement. So that's interesting, because the client may have said 2 days afterwards to the witness, 2 days ago, I signed my will. And so the intent that the witness is attesting to is not the intent at the time of the acknowledgement 2 days later, but the intent at the time of the signing, so that the client is going to want to represent to these witnesses that 2 days ago when I signed my will, that at that point I intended it. And I get a lot of this because there was a couple of law review articles on this code section out there, and they made a big deal of the timing of the intent being at the time of signing, not the time of some later acknowledgement. So this section is a big deal. It's important. A lot of us don't know about it. Share it with your friends. Maybe put the idea out a little bit more. So I want to move on to number Roman numeral 7, and that's the global assignment. And a lot of you are familiar, probably most of you are familiar with the so-called Hegstad petition, where you have a trust and there's assets that were not fully transferred into the trust in the normal way, but there's an assignment that says I assign either these specific assets or all my assets to my trust. And so there's pros and cons of doing that, but certainly I think we have to think a lot more about this global assignment in a COVID situation, because the person might die soon, and the person might not be able to sign other documents, might not be able to go to the bank, might not be able to get the beneficiary change forms for different assets. And so that global assignment would be very important. But in some cases, the client already has, for example, IRA and retirement plan beneficiaries. Are we seeking to override that? We need to think about that if we're doing this global assignment. Maybe the client has POD accounts, payable on death, or ITF accounts, in trust for accounts, where it's in trust for somebody. Should this global assignment override that, or should those things be accepted? And if we accept it and say no, it doesn't override these things, do we know what those things are? In other words, we ask our client to tell us who your beneficiaries are of your IRAs, retirement plans. So this global assignment issue, there's the issue of doing it in this situation. There's an issue of tailoring it and exempting assets. But if you exempt assets, you're basically kind of reaffirming your old beneficiaries, and because you're not seeking to change them. But you may not even know what the old beneficiaries are. So you're kind of in this situation. But maybe you can say to the client, look, since you don't have the confirmations of your old beneficiaries, and we don't have time before we sign these documents to get it all, you have to tell me if you think it's safer / better to reaffirm your old beneficiaries or to somehow try to say that this global assignment acts as a change of those beneficiaries. And then let the client tell you which way to go. So that's really a big deal. The use of the global assignment with a situation with COVID. Maybe the client can't sign his notarized, can't do a lot of things, can't formally transfer his assets into the trust. And if you've explored it and the client winds up having a probate, but at least you've explored these issues, that's certainly better than saying, well, we'll just sign this and we'll worry about funding later. Well, the later maybe will never come. So now we're moving on to Roman numeral 8. And this is really the situation where the child is worried about the parent, but the parent isn't worried much. The child is calling you, but the parent isn't calling you. The child tells you that his parent gave your name to him, and you're already the parent's lawyer, either because you did the old trust or you did whatever you did. So you've got this problem, and the quote I give you is, older adults are often masters in turning their attention away from information that is threatening, upsetting, and negative. So they've postponed a lot of things in the past, and now they've got COVID and they're still thinking about postponing because they're going to pull out of it and everything's going to be fine. And that can arise where they don't have an estate plan, but it can also arise where they have an estate plan and the client and the child tells you, for the last year, my father was telling me he's going to call you to make these changes. And now he's got COVID and now I'm calling because he wants to make these changes. And of course, the first question, well, the real question is to communicate with the client. We'll talk more about that later. But there's another question that ties into this as to whether this child that's calling you is going to be benefited by what he's calling you about. And lo and behold, a lot of times that child is, and the issue of convincing that child to back the heck away from the situation so that you don't create some sort of presumption of undue influence, because the very child that is seeking to enlist your aid in some project that he says his father or mother wants, if ever his involvement invokes a presumption of undue influence that hurts him, now that same child could be saying to the lawyer, hey, you should have shooed me away because your failure to do it caused me a problem. Well, you're darned if you do and you're darned if you don't. These are problems you have to look at and try to figure out what to do. So the first one, A, is, will the client let his or her lawyer help him or her give recommendations regarding the issue of diminished capacity? So this client has diminished capacity, and the child knows exactly what to do, and the child knows exactly what the parent wants. But all of that could be either in the child's mind, or it could be something that the parent said to the child because he's afraid of the child. It could be a lot of things, and so the question is, will the client let the lawyer get involved? And one of the problems is involvement really means spending some time, because the child who calls may be willing to put dad on the phone so that you can do this estate plan by not seeing the client, having dad on the phone, and the child is sitting right next to dad, and that's all you get. And no, that isn't all you get. You don't have to content yourself with that if you don't accept that. And I'm going to even say it more, that when you allow this child to initiate everything, to get dad on the phone, to sit next to dad, you could get yourself into a horrible mess. Maybe you're in a conspiracy with the child, at least as alleged by some other child. There's a lot of maybes. There's a question of letting the dad, giving the dad some privacy and figuring things out. So one of these issues are, Dad, I may have to go out to meet you 2 or 3 times, and what about the prices on that? Well, you can't come in. Maybe can I Zoom with you and I'm here and you're there, where there's nobody in the room, it's just you and I. Can you talk to him without physically being there, without other people being there, and you're worried that the parent is telling you what the child wants to hear, because maybe that child is going to stop visiting the parent if the parent doesn't say what the child wants, and so the parent is very dependent on that child. So you're trying to figure out, how can we get that child away? Maybe there's other people that can get involved in the situation who are neutral, and you can feel like maybe there's a assisted living where people do go into the parents' room, and so they can verify that nobody's there and nobody's been there in the last hour to fill the dad's mind with, what they have to tell you, what they've been told to tell you. So the question is, will the client with diminished capacity allow you to do some due diligence? And that's not always clear. And one of the issues is, all right, we're not going to change the trust. We're not going to give different amounts to different people and cut people out, but we're only talking about the issue of the resigning as trustee, or perhaps adding a co-trustee, which is a little bit less severe than changing the beneficiaries. But even changing trustees or resigning can be a big problem if the client claims later he or she didn't understand what was happening, or later the client claims that the new trustee took advantage of them, and why did you, my advocate, allow this to happen? Well, one of the things I tell all clients, they don't have to have COVID for me to tell them, is that if you are going to resign as trustee, and even if you're going to add a co-trustee, that you have to trust that person 1,000%, because ultimately, even as a co-trustee, they could clean out the account. So do they trust the person 1,000%? How do I interact with them to make myself feel like they're giving me, a real answer that we can do something on? And that if you resign or you add a co-trustee, I can't just snap my fingers and remove that person. If that person doesn't want to be removed, and if they get litigation counsel, and if they claim that now the client, at the point that the client is unhappy, is irrational and incapacitated, that client who thinks he's still fine is going to have a lot of difficulty. So we don't want them adding a co-trustee or resigning if they think they might have buyer's remorse. Now that's a high standard, and maybe you'll see it differently, and that's okay. But what I want to do with this client that's thinking of resigning or adding a co-trustee, and let's say they've got COVID, and we've dealt with a remote notarization, we've dealt with some of these other issues. At what point do you bring the new successor trustee or co-trustee into the conversation? Well, one way is if the client seems to be happy, to try to meet with the client privately enough for you to satisfy yourself that this client can really live with what is being done. And then only after you've done enough due diligence to bring the child in. So basically, if the child thinks that you're the child's rubber stamp, so the purpose of that private meeting is for you to convince dad or mom to do this, you're hopefully going to tell that child, no, dad may not do this. I remember I had a client once where I asked, I couldn't tell if the client really wanted what was going on. So I said to him midway through, well, do you want your son, if he's co-trustee, to be able to act independently of you or only with you? And he didn't understand what I was getting at, but he came back and said, well, only with me. And I said, well, then this whole thing doesn't make sense, because right now he can't. He wants to act independently of you. You've just told me you don't want it. So I kind of fleshed that out of that fellow. And ultimately, what happened is they went home and they went to another lawyer. And I'll bet you 9 out of 10, the other lawyer who was maybe beholden to the son did the amendment, and it got done. But I know that I was not the son's lawyer, and I know that I had to do my own level of due diligence. And in that particular case, they flunked my level of due diligence. So We talked about the 1,000% test. Now, how will the banks and brokers and others be notified of the change? So, for example, sometimes the lawyer assumes that after you've done all this, the successor trustee will bring dad to the bank with him or her. And sometimes they don't do that, and they don't realize they've got to do that. And it's ridiculous, but you kind of have to pound them on the head to do that. But now with this COVID situation, even if it gets signed, and even if you've got a tax ID number, and even if you do all these things, how is the bank and the broker going to handle this? So the one thing is to say to dad, you need to talk by phone, if at a minimum you've got COVID, to your bank and the broker about what you're doing, and see whether they're okay with it. Not that we're asking their permission, but we want to know what their procedures are. And if they have a specific way of doing it, or they want to be involved in a certain way, or if they need to know certain things before they're comfortable, or they have a certain form, figure that out up front. Because if we do the resignation and then the bank won't accept it because dad won't come in, that's a problem. And I don't have the solutions. I would probably give it to some sort of litigator to deal with it. But let's talk about that up front. Roman numeral 9. I know we're getting towards the end. Client says he or she wants to be left alone, and that's sometimes the bottom line. The family members may try to institute a conservatorship, but if the client has capacity and is not in favor of the conservatorship, you can't represent the drafting lawyer. The dad's lawyer cannot represent the conservator. What happens if dad is clearly incapacitated? You did the trust and the will, and the proposed conservator, the nominated conservator, comes to you. I would think it's okay that you can represent that person if dad is clearly incapacitated, but I have not seen a case specifically saying you can. I think most people believe that's true. Family members or non-family members may present your client with an amendment to the trust or with the power of attorney. You've got a lot of people that will do amendments and powers of attorney, not for the client, but for the agent or for the trustee or for the beneficiary, and they somehow think that's okay. So you may be presented with some document that some other attorney has prepared, and it may have been that your client just signed the thing and never did very much, and maybe the litigators have to come in. And now with the COVID, we're going to have a lot more of that. The family members may not be supervising the caregivers. The family members are happy that the caregiver is in the facility and is taking the risks of getting the COVID. And then later they find out that as part of the compensation, they had the client amend their trust. So you're going to be faced with those caregiver issues, and talking to the family about, are these caregivers really having too much control? And how do we deal with that if we can't have control? One of the children may be the caregiver, and now you've got a child that perhaps knows about the estate plan, and they want to reward themselves, or dad wants to reward them because they're the caregiver, but they've of course waited until the client already has COVID. So those are real issues. The client may be isolated from the family, only has the caregiver living with him, is the family Skyping? Are they FaceTiming? Are they Zooming? Are they doing other things? That may not be enough, but that's something. It's more than nothing. And you've got a lot of isolated clients where the child, I talk to my dad once a week. He's got a caregiver there 24/7. Seems ridiculous to me, but you'll see that, and those kind of situations are more ripe for abuse. The client may be isolated with a family member caregiver. That may be not as bad, but it from the other family members who get left out, that they may see it as just as bad. The client may be isolated with no caregiver, nobody there, but some services are provided by the facility. So what are the level of the services? And is the facility somehow, somebody at the facility in connection with preparing those services, going to wind up altering the estate plan? Now, there's a lot of interesting things that are out there that I was reading about in connection with COVID, and how to stay in touch with your family in that situation. There's something called PAPA, P-A-P-A. It links college students and older adults for virtual conversation. So that's great for COVID patients, unless that college student takes advantage of your dad. So when you have these things, maybe you want to find out about them, but you also may want to back away from it if you can't figure out a system to supervise. There's another one called Stitch, social networking site for seniors. You can go on that site, you know, you don't feel so bad, you're not depressed. You go on that site and you've got a new friend that's now your new beneficiary. So how do you deal with that? And the client is certainly not saying to us, well, I want you to monitor my use of Stitch and whether I'll get taken advantage of. We're often not given the opportunity to do too much with that. There's another one called Talkspace and another one called BetterHelp, which connects people to virtual counselors. So who are these virtual counselors? Maybe they're could be thieves, and maybe they're very honorable people. The AARP has mutual aid groups. These mutual aid groups are wonderful people. They're volunteers, but who are these volunteers? They could be good, they could be bad. So there's a lot of strange and interesting things out there. So now I want to come to the last point, which is kind of my editorial area. And my editorial area starts with this concept that most of you, or maybe all of you, have heard about, called the scrivener. And the scrivener basically goes back to Old England, where most people could not read or write. And so you would go to somebody and you would dictate a will or a contract or some other document. And that person, all their duty was to write out what you told them. And no matter what you told them, they were never liable for it, because all they were doing was writing what you told them. If it was nonsense or if it was stupid or whatever it wasn't their problem. So I found this in the past, but I'm finding it much more now, that our clients and these children who call on behalf of our clients are trying to make us, the lawyers, into scriveners, because they're trying to tell us what to do. They want X. You say, well, wait a minute, I need to do due diligence. They still want X. They don't care about the due diligence. They want X. You think maybe they should do Y. They don't care about Y. They want X. They don't care about what you want. So I'm going to give you one example for all this, and because it can come up in a million different contexts. The process that I'm going to go through with you is one that a scrivener not only would not go through with the client, but would not know to go through with the client. So a client or a member of the client's family requests that a power of attorney be prepared. So I get a lot of this power of attorney stuff, and I have my own prejudice. I'm very prejudiced against the power of attorney unless I've gone through this process, which a lot of people don't even want me to go through, because they just want to dictate to me to do it. And I'm thinking, well, why don't they just go to LegalZoom, We the People, a stationery store, and do the power of attorney if they're so sure that that's the right way? They just want me to do what they tell them to do, which to me is a scrivener. But that's just my opinion. So first, with this power of attorney issue, we need the direction to come from the client rather than from the family member. We know that a power of attorney can be a license to steal. So the idea that the family member calls you up and says, Dad wants a power of attorney and he asked me to call, that doesn't fly with me at all. Next, not only do we need to talk to Dad, we have to assess Dad's competence. And we need to assess Dad's whether he is being unduly influenced by anybody in connection with this. And we need to remove the attorney, in fact, the potential agent, from this process. And we need to explain to the client that this power of attorney could become a license to steal. And we'll talk about amending the trust to add a co-trustee or resign. I find that when we amend the trust to add a co-trustee or a sole trustee on a resignation, that the process includes a lot of the safeguards in it, getting from point A to point B. But this power of attorney tends to be a quicker thing. And a lot of times the safeguards that I would like to put in, and probably that you would want to put in, all the I's don't necessarily get dotted. And I don't even want the darn power of attorney, but if you want them, certainly you go through the process. So not only do we talk about this license to steal issue, but we talk about, does the bank or broker have its own power of attorney form? So we create our own power of attorney form for the client, and then 2 weeks later, 1 week later, the client loses confidence. So now that power of attorney is the only one. So now they go into the bank and the broker, and now they present the attorney's power of attorney to the bank or the broker. And now we find out for the first time that the bank or broker has its own power of attorney form. And now we say, well, Dad can't sign that because he's incapacitated, but 2 weeks ago he signed this, or 2 months ago or 2 years ago he signed this. And we find out what their policy is on it. And we don't want to find it. We want to find out up front from the bank and the broker what's their power of attorney form, because if we use that and turn it back in, we're going to have a lot easier time than if we have our own form and try to get it validated or ask that it be validated, or we go to the litigator and we go to court to get to try to force the bank or the broker to honor the power of attorney. The attorney, when he prepares this power of attorney and the client is now incapacitated, you have to look at the bank or broker's side of this, because they want to see the client, and the client is not coming in to talk to them and say, yes, everything's fine. But if you sign their power and the client goes in with the agent and says to their banker and their broker, hey, I've just given Billy this power of attorney, I've got it right here, and I want you to honor it, and it's your form, it's going to go a lot smoother. Now, if the assets are in a trust, does the trust allow for the trustee to give a power of attorney? I see a lot of times that trustees give powers of attorney. Some banks and brokers look at the trust to see if the trust allows for it, and some don't. And a lot of lawyers put it in the trust that, yes, you can do that. I don't put it in mine. Why? Because I'm worried that the cleaning lady will take the mom or dad over to the bank or broker and have them do this power of attorney on the trust. Well, one level of defense is you've got to do an amendment to my trust to give that trustee the ability to do a power of attorney that may or may not help. Some banks and brokers, even if you put a provision in a trust that says that the trustee can give a power of attorney, some banks and brokers says we don't allow our trustees to give powers of attorney. So you have to figure that out up front. So in a way, my big point on all this is, do we really want this power of attorney? Do we instead want the client to look at the resignation / amend trust to make somebody who is a backup trustee a co-trustee and go that route? I am prejudiced in that direction. It's certainly legal to do the power of attorney route, and if a lawyer likes that or it presents itself as more feasible, I'm not against it. But really, with COVID, we're going to have a lot more of these situations coming up, a whole lot more. And if I think all of you see issues, but I think unfortunately there's some lawyers in some cases that don't see the issues, and it's those unseen issues that come back to bite them. And we're trying to be a nice guy. Somebody that's not the client calls us. You feel bad that their dad has COVID, so sometimes you loosen up on what would otherwise be your normal operating rules, and you have to have your own pre-thought out ideas of what you do in a COVID situation. So I'm going to hit the Q&A and see what happens.
Question, in a nursing home or similar situation, can witnesses be looking through a window or an open door?
Well, I think the open door is more likely to work, and the window, I've never seen a case on it. Maybe some of you have, but if it's an open door, you want to make sure that everybody hears each other. If it's a window, you want to document, and maybe this is the only way you can do it. And it's a great question, actually, because if you can still hear each other through the window because everybody's kind of yelling or talking loud, in my mind, if you document that you were able to hear the person as well and see the person as well, then you might have to give that a shot. And I'm not blessing the talking through a window, but you may have to do it with and without the blessing, and document that everybody could hear each other. And you might even go through some process in the signing where you say, Mr. Smith, if you hear me, say yes, and or put up 4 fingers or 5 fingers or do something, and do that periodically to really be sure.
Okay, we have, I'll help with these questions. What are your thoughts about using a witness attestation in a trust modeled after a will?
In other words, well, we
Using
have
witnesses.
attestations in wills, and we could take an attestation of a will and modify it to the trust. So I think that's fine. And we would have to take this attestation to the will and modify it where they're not attesting to witnessing the will, but they're attesting to a phone conversation before and after where the person acknowledged. And so we could take that will attestation, modify it for that. We could have somebody watch somebody sign a trust with no notary, but he watched them sign it, and they can have a modified attestation for that, and that's fine. And actually, you might want to get two kinds. You might want to have the witness give you something in his or her own words, so it isn't two-stage, and you might have the witness also sign the attorney prepared attestation. You've got both.
Next question is, how do you advise assessing capacity and lack of duress if the client is technologically challenged and the son or daughter needs to be present? It's
Well,
almost
one of
a
the questions that ties to
that,
this is what
yeah.
level of concern and what level of activity do you put in, and if it's a trust or an amendment which doesn't change what he did 2 years ago, or doesn't change the intestate shares if he didn't have any will or trust before, then your level of concern goes down. You still have to have concern, and so the problem with this is that the child says, I need to be there because dad is technologically challenged. But if that child is getting a double share or something, and he's there under the guise of helping dad, maybe he's helping himself. And so one of the ideas is, who can we get besides you to help dad? Does dad have friends? Well, they've all died. Well, what about dad may have some brothers? They've all died. Well, the brothers have children. These are nieces and nephews who maybe are getting nothing. What about the old neighbors? So you start throwing things out, and maybe the child is saying no, no, no to everything, and maybe it's no because these people don't exist, and maybe it's no because the child wants to supervise the situation because he doesn't want to let dad say anything that would derail where things are going. So you have to really assess all that and document your efforts and try to figure things out. And one of the options is not to do anything, but you kind of have this issue of where you swim after somebody to save their life, and halfway out you turn back. And there's tort cases that say once you start, you have a duty. So the question is, when somebody calls you and says, dad's in a nursing home, you don't know him, I want you to go out there. Some lawyers will do it and some lawyers won't. And you can be one that doesn't. And if you are one that does, then maybe you need to get some information before you decide whether or not you're going out there, rather than just go out there once you get there, find out what's going on. Because I don't know that it analogizes to the person who's swimming out to the save somebody and turns back, but they're asking a lot of you if they ask you to go out somewhere to meet somebody where you don't know about. And so if you ask the family for some cooperation, some information that either will make you more or less comfortable to help you make a decision as to whether or not you're going out there, and the people are already starting to be huffy with you, and like, I thought you were a lawyer, or the person who referred me thought you were a nice person. So they want to make you feel bad. They want to make, not everybody, but in some cases, they want to make you feel bad. They want to make you feel guilty. And guess what? Sometimes it works, and because we're human beings, but we have to watch ourselves.
Do you find the courts will honor a global assignment or a Schedule A that includes any and all bank accounts with respect to a bank account acquired after the assignment or schedule was executed?
That's a
different for real
great
property.
question.
What do
And
you think?
I've done some Hegstad petitions, but there's a lot of people that have more hands-on with that. But I believe there was a case within the last few years where it was more liberal with real estate, because prior to that there was some rulings that you might not get your Hegstad if you just simply say all my assets, real and personal or whatever, and then you've got real estate. But this newer ruling, you have a better chance of getting real estate confirmed on a general assignment. And what's interesting to me is these general assignments, one probate judge might say, well, if it's a general assignment, it's fine, everything goes. Another judge might say, well, the trust was signed and the general assignment was signed 5 years ago, and this real estate was bought subsequently. So therefore, it doesn't fly. So another judge might say that. But that second judge, you might have to be prepared to say, well, Your Honor, this guy who did the trust 5 years ago, did the general assignment 5 years ago, he never worked after that point. So he assigned all his assets into the trust previously. So therefore, the assets that were used to buy the real estate 5 years later must have already been in the trust. And if those prior assets by the prior assignment were in the trust, then the new real estate is in the trust. Might or may not fly, but you might have to think on your feet with that. And judges, are very, I guess, individualistic about it. And I think if you're polite, you'll have a better chance, and creative.
I think we got all the questions, and it's perfect timing because it's 4 o'clock. I want to thank Randy again. Great presentation, thoughtful, so interesting and very practical and useful for all of us. So thank you, Randy.
Thank you all.
Okay. Bye, everybody.